doesn't say anything. And then I find out that I had a hearing problem since 2006, and they didn't do anything about it. On a legal document, when I went to see a panel hearing or a panel evaluation by Workmen's Comp panel or something to give me a legal document that I'm deaf or I have a severe profound hearing impairment, which is over 50%, by the way. I mean, it just, they didn't do anything for so long, it just, the damage is done. There isn't anything you can do. You know, and the fact they denied me medical treatment, they denied me the right to go to work, full release duty to go to work, and they never paid me every week or every 2 weeks. They just didn't do anything. And that document, that notice of offer of work backed up by the QME report, saying I can do my customary duties and that I have a permanent disability and that I'm able to work, backed up the notice of offer of work good for 1 year. And they took 15% out. And out of what? I don't know. I didn't work 1 day on my 10 o'clock shift for Eureka run. So I don't know what to say. Now my wife is sick. So she needs to go to the doctor, and we can't go because they took the lifetime medical that I bought in 2002 or 2003. And, you know, Jesus, it's bad. I don't know what the Workman Comp Judge Bill's going to do, but he needs to send it to trial. He needs to send this case to trial. Because the dispatcher, by changing my 10:30 to 11:15, put me in violation of Department of Transportation on December 6, 2010. By him changing the time, taking the time from the time clock in the driver's room, okay, and changing the time on my logs, automatic on-board recording device, 395.41.6 and 295.8 tamper-proof. And he's not allowed to alter or change anything on them logs, and he just went ahead and did it. Now, maybe he was authorized to do that by Mike Sadler. I don't know. I don't know why DOT would make regulations and rules if the company could just change them. But in any event, on December 6th, he changed my time. So on top of everything else, he just flat out sent me home on December 7, 2010 because I received the notice of offer of work on December 1st. 2010, there's no doubt about it. And the fact that I applied for FMLA twice and then I got a third opinion says I do qualify, you know, maybe 3 days before I received that letter, and then find out I'm on FMLA when they flat out sent me home on December 7, 2010. And I can't get any medical treatment on my pinched nerve fixed because they denied it with Dr. Baby. Because of that PR2 report, and they sent the letter about the sprain and all of that to Dr. Hubbing when they should have sent it to Nancy Perdillo. She's the one that said it was a sprain, and I don't remember if she sent me to the hospital or whatever, and I don't think that's relative anyway, because they didn't take an MRI. They didn't do a good job. Obviously, I guess. I don't know what they're supposed to do, but I don't remember taking no MRI. And I remember her saying it was a sprain, so why would they send a letter to Dr. Hubby when it was Nancy Perdillo who I saw? Or maybe I went to the hospital. Why didn't they say something? I don't know. The fact is, Judge Bill needs to send it to trial, and he needs to enforce the notice of offer of work. It's been denied 3 or 4 times to put me to work in the union. They knew that I asked them, the VA was there, are you an authority on severe profound hearing impairment? And they denied me to finish the right, to finish the panel hearing. And they went into caucus. What happened? I don't know. But I'm not fired because the union attorney said I was fired on the 16th. But all disciplinary action was denied on December 17, 2010 by Mr. Nicewanger, VA. corrected. Now, I went to the police. I went to the highway patrol office. I went there, and I saw the DOT man, and my wife was standing right there when he said that it appears that your logs have been altered, and where are the rest of your logs? Well, that's what I'd like to know, because they didn't give me all my logs, and Mr. Nightformer knows that. So, and I told Mr. Nightformer the statement that the dispatcher made on December 7, 2010 was incomplete. He didn't say everything. He didn't tell the whole truth and nothing but the truth, so help me God. And falsifying documents, I don't know. I guess the question needs to be asked, do you have the authority to falsify or alter laws by the Department of Transportation or company policy? They need to ask the question, because he put me in violation. Okay? I mean, if I would have got stopped, I might have got rolled up, because there's no way I could do all that work and in that amount of time, because when you get stopped, they ask you, how did you get from step A to step B and do all that work and get there in a short amount of time? I mean, he deducted 45 minutes. From 10:30 to 11:15, it's 45 minutes. That means I did all that work. It was in Gustine. From 10:30 till you go. From 15, I had to hook up, and I had 100-gallon tanks that didn't have no fuel, and I had to do a safety check, which they pay us a half hour or 15 minutes, whatever it is. I had to do all that work, right? And I was in Gustine in that amount of time. I get rolled up. There's no doubt about that. So by him doing that, he put me in violation. And then he sent me home December 7, 2010, saying that I intend to, how am I going to falsify the logs if the machine is tamper-proof? It's worse than that. If he hadn't changed the time, it would have showed that I was there on time doing my work. That's what the logs would have established. It would establish that fact beyond a reasonable doubt. Now, punching in late on the company time clock, which I wasn't late, okay, it doesn't mean a damn thing. Because my logs establishes the fact beyond a reasonable doubt that I get paid by and disciplined by, will prove the fact that I was there doing my job. Now you take the company time clock, it doesn't have any logs, doesn't have a time card. What does it do? It doesn't establish anything. And I got an algorithm sheet that's printed out from the tractor automatic onboard recording device, that prints out minute by minute. So what they're trying to do probably is ignore the fact of my logs in the algorithm sheet. They don't want to accept it as beyond a reasonable doubt that I'm innocent. Even though the DOT inspects it to make sure that you're not in violation of what the dispatcher did, put me in violation. So it needs to be noted. But, and here I sit, and they didn't let me log out or punch out on December 7th, and the dispatcher not only changed my time, but on December 7th, 2010, he asked for the log, the key to the tractor and everything, and I don't know what happened to it. He could have threw it in the garbage, it disappeared. I never got paid for that day, and there was a room full of truck drivers there. So, and then I found out by Judge Grill, Workmen's Settlement Conference, he ordered the two attorneys to get me a legal document, and come to find out that I do have a severe profound hearing impairment. I'm partially deaf, more than partially deaf. I mean, it's more than 50% in both ears. So, and background noise and everything else, yelling or screaming or, I'm not going to understand a darn thing a person says. And then, the guy's talking about. I don't know what the fuck they're talking about, some posting or something. I don't remember that. I don't recall. I don't know. You know, I'm just, when you're deaf, you don't know anything. When you're deaf, you're not sure you're comprehending anything. Communication is very null. Okay? So, and I'm sure that anybody that's an expert on severe profound hearing impairment will tell you the same thing. So, and I don't have hearing aids. Since 2006, they didn't do anything. So, whatever they say or whatever they try to say, you can just forget about it, because I was deaf. I had a severe profound hearing impairment, and they didn't accommodate me with any hearing device or anything else to make sure that I understood what the heck was going on since 2006. So they need to put me back to work and let me have automatic retirement on September 7, 2013. With all back pay and benefits and everything, 14 hours a day, 7 days a week, because I got 200 people underneath me, and it's a 24-hour operation. And I fit into Eureka around on the notice of offer of work at 10 o'clock in the morning, in which I didn't start one day. Not one day. Okay? They didn't honor it. And it took 15% out of what? I don't know, because it didn't pay me every week or every other week. So I don't know what the heck's going on. I haven't had my day in court. They didn't finish the panel hearing. And the union attorney said if I wish to pursue it under workman's comp, I could do so. So I have permission from the union, because I've exhausted everything, I guess, because VA and Mr. Nightrover is not going to complete the panel hearing. And now that I'm legally deaf, I don't know what his position is. So the union isn't doing anything, and they said I could pursue it under workman's comp, so Judge Bill needs to know that. And when I go to trial, because I'm asking for trial, then at Superior Court, so now maybe we can get it straightened out there, exactly what's going on and what the rules are and procedure are, because I don't know. All I can say is give them the facts, and then they can decide from there. So I should get all that whole, and the RSVP needs to be made whole. My lifetime medical insurance that I bought in 2002, and been paying into it, and the company's been paying some into it. But the point is, I put $3,000 plus out of my pocket so that I can get credit for 5 years. Okay, so that I can retire anytime within that 5 years if I wish to do so. But since I have 2 kids in university, I couldn't, so I let it ride. Okay, but I was paid ahead. I didn't even have to make payments every month because I was paid so far ahead. So I shouldn't have lost it, but they just flat out sending me home and notifying Health and Welfare and RSVP that I was fired, which is incorrect because it was denied on December 17, 2010. But that's not going to do me any good until I get this workman's comp case over with. So everything is laying on workman's comp decision. My life is on the line. So it's up to workman's comp to decide what's the correct action on this matter. So, and I guess that's why I'm sitting here. I mean, they're going to have to pay me for every day because they're wrong. I'm unable to obtain employment because of the dispatcher's actions on December 7, 2010 and December 6, 2010. And there's no doubt about it. So, and I didn't get to speak at the panel hearing because they didn't give me a listening device, and that's why they put the meeting in a fifth, because I didn't say anything. They didn't accommodate me with one listening device. And I asked them if their authority on severe profound hearing impairment. They just flat out sent me home. So there's no excuse. They don't have an excuse not to accommodate me. They should have sent me to a hearing specialist and found out if I was telling the truth. my hearing, and I'm waiting for a court date for Modesto Legal Clinic right now. Okay, because I have the legal documents, and I'm asking to enforce a notice of offer of work from December 7, 2010 for 1 year. For 1 year. They owe me for 1 year, plus back pay and benefits and everything. Okay, the Eureka at 10 o'clock in the morning. And they need to make me whole and retire me. I need a letter from personnel or from their insurance company, from Mr. or Mrs. Morles, who is my new claim adjuster, who sent me a notice of offer of work in 2013 to sign it and send it back, in which I did, and my attorney said to report to work immediately. And I did, and they just sent me home, and the union just followed up the same thing that Safeway did in Tracy, California. They just denied me to work. That's 3 or 4 times. So, nothing I can do. You know, my hands are tied. Going to need a court order. And I'd like a court order for my back pay and benefits, because if I don't get one, they're not going to pay me. So I need to get a court order for back pay and benefits for 14 hours a day, 7 days a week, because it's a 24-hour operation. Anybody that works below me, I get paid for that day. And I should also note the fact that I was hired in 2002, and I was born September 7, 1940, and I'm going to be 73 years old this year in 2013. And I have a permanent disability. In fact, I have 2. I'm deaf, and I signed a document to that effect when I had that panel examination, and the QME report says I have a permanent disability. And on top of that, they didn't honor the FMLA, even though they were informed 2 or 3 days after the fact that they just flat out sent me home and didn't allow me to clock out or log out or whatever to dispatcher on December 7, 2010. So they need to pay me for those 7 days a week, 14 hours a day, because he was incorrect in his actions, and I was unable to obtain employment because of those said actions. And I didn't have all my logs on top of that, and I got a statement and a witness stating that the dispatcher did alter my logs, so there's no way I'm going to obtain employment. And he didn't tell the whole truth and nothing but the truth on December 7, 2010, when he made his statement. And he did say that I was there at 10:30. I was there working with at that time, and I don't remember everything was said in the letter, but the Union Local 439 Teamsters of Stockton, California has a copy of that. And Safeway Distribution Center in Tracy, California has a copy of that. And he's working and I'm not. Why that is, I don't know. But he's working and I'm not, and I should be returned to work like 1,500 other Teamsters because they didn't meet the time limits. And that guy, he violated the DOT regulation and company policy, but yet he's working and I'm not. So that's not fair. I should be returned to work. And so that's about it. I'm Julio Zamora, invoke double standards. Life is not... I'd like to have Judge Bill consider the fact that I have a lifetime medical plan, RSVP, that, like I said before, I paid into it 5 years ahead, $3,000 plus. I should note that lifetime medical plan covers medical, prescription drugs, Delta, dental, hearing, and at least I think it does cover hearing. And I should also note that Safeway never accommodated me with any hearing aids or anything else. I did obtain some hearing aids, but they were the wrong ones. They didn't eliminate background noise, etc., and they're very old and they don't work very well. When I took the panel examination for Workmen's Comp to get a legal document, they noticed that the hearing aids were really, really bad shape. They worked, they didn't work. So anyway, the point I'm getting to is the fact that if for some reason or another that Judge Bill doesn't enforce the notice of offer of work backed up by a QME report that states I can do my customary duties and that I have a permanent disability, if for some reason he doesn't enforce that, anything else. So that's why I say my life is on the line. And the fact that my lifetime medical is 90%, maybe Judge Bill or the Superior Court can increase that to 100% due to the fact that they didn't do anything for me since 3/21/2009. Okay? So I'd like him to take that into consideration. And so again, I need that lifetime medical, and the only way I'm going to get it back, that RSVP and everything else you made whole, is to get a court order. Because they won't do it if I don't have a court order to return to work and to made whole. And I won't get paid the 14 hours a day, and they won't retire me on my birthday in 2013, September 7th, with a letter stating that I retired from Safeway with a permanent disability and that I have lifetime medical insurance. So that way there, as you know, I'll be able to have medical insurance for my disabilities. Okay? Anyway, that's my statement, and I hope he takes it into consideration. The fact that a double standard is the application of different sets of principles for familiar situations or to different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standards has long been applied as early as 1872 to different moral structures on men versus women. A double standard, thus, can be described as a sort of bias, morality, unfair suspension towards a certain group of the principle that all are equal in their freedom. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence, that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase, life is not fair, may be invoked in order to mollify concerns over double standards. And I, Julio Zamora, invoke double standards. Life is not fair. Go with God. Okay, April, stop the recording.